Thank you, Madam Clerk. For those that were not here this morning, welcome to the afternoon session of the January docket of the Court of Criminal Appeals. I'll quickly introduce panel again. To my left, Matt Wilson here from Jackson. To my right, John Campbell from Memphis. I'm Ross Dyer from Memphis. Again, if you weren't here, which I think everybody was, but I'll say it anyway, 20 minutes aside, please let us know if you'd like to reserve any time for rebuttal prior to starting. With that, do we have any preliminary matters?
Yes, Your Honor. State of Tennessee versus Christopher Lance Osteen in Ray David A. Walker.
Mr. Walker, are you here today?
I am, Your Honor.
Can you step up to the front, please?
Yes, Your Honor.
Thank you, Mr. Walker. As you know, you're here on a show cause from this court. Before we get started, I do need to inform you of two things. One, you do have the right to counsel if you'd like to invoke that right to counsel. And then two, if we do proceed, that you consider yourself under oath as you're questioned by the court. Do you understand both of those things?
Yes, Your Honor.
Would you like to invoke your right to counsel?
I believe so, Your Honor.
You would?
Yes, Your Honor.
Okay. With that being the case, do you have counsel here?
I do not, Your
Okay. Madam Clerk, we will reschedule this. We may do it by a Zoom as opposed to in person.
Yes, Your Honor.
How quickly do you think, and I'm not rushing, but how quickly do you think you can get counsel, find someone to represent you in this matter?
Probably within 30 days.
Okay. Let's at least tentatively plan, enter and have an order, Madam Clerk, that says 30 days. We'll refine it with the staff attorney, but that's what we'll do at this point then.
Thank you, Your Honor.
All right, thank you. Call the first case then.
Tracy V. Boyd Jr. versus State of Tennessee.
Good afternoon, Your Honors. May it please the court, I am Mitch Raines with the Public Defender's Office. I'm here today on behalf of Mr. Tracy Boyd, who's in the gallery with us. And at this point, I'd like to reserve 4 minutes for rebuttal.
All right.
Thank you, Your Honor. We have raised 3 issues in this case. The first issue is an error with or a deficiency with the trial court's order denying Mr. Boyd's post-conviction petition. The state agrees with us that the order does not comply with Tennessee statute, but we do differ on the remedy for that. The state has asked for a limited remand for the court to flesh out its order. We're asking for a new post-conviction hearing.
Why would your client be entitled to a new hearing?
Your Honor, given the time that has passed since the hearing took place, I think it would be more efficient to have a new hearing as opposed to just letting the trial court or having the trial court just rely on a transcript, especially because there were credibility determinations that were made and more than a year has passed since the time of the hearing.
Do you think in that year the trial judge is going to have changed his mind as to whether he believes X or Y?
I think in that year the trial judge may have, as we're all prone to do, forgotten certain aspects of this case or any case that might have taken place that long ago. So that's why we asked this court for a new preliminary hearing on
the PC.
Yes.
So, admittedly, I have not looked at the order. I know y'all have talked about it, but I haven't actually pulled it up and looked at it.
Yes, Your Honor.
But my question, however, is he's got an order, you've got a transcript. I'm assuming, and I agree with this assumption, that the trial judge took notes during the hearing. And the reason I keep kind of asking these questions is because you said it'd be more efficient. Well, I mean, would it not be more efficient to give the trial court 30 days and let him look over everything and enter an order as opposed to setting a hearing, make sure witnesses are there, make sure everybody's ready, which is probably going to take more than 30 days?
Well, I think that in this case or any case where this amount of time has passed, it's really just sidestepping any problems that could have occurred because of the time lapse. So to ensure that all of the bases were basically covered in a way that the trial court can clearly express in its written order what its factual findings are, that a new hearing would be the best way to do that, so it's then fresh on the court's mind.
Well, you cited the Tate case. I mean, the Tate case, Tate won because it came back. But the Supreme Court in that just remanded it for the written order, right? There was no other hearing.
That's true, and I don't know what the time frame was for that. I don't cite for Tate to say that in this case a new PC hearing is required. I just think that from a judicial economy and from an efficiency standpoint, that would be the best way to get a proper order so that we don't have this issue again.
But you don't have any authority for that.
I don't. I don't have any authority that says this court also can't do that. So again, citing judicial economy and efficiency, I think that that would be the best way to ensure the best result.
So the state also seems to suggest in their brief that we can reach some issues, but we can't reach others.
Yes, Your Honor.
Is that the right way to do it, or do we send it back like, hey, we dealt with 7, 8, and 9, but you got to do 1 through 6 again? Or do we send it back and say, hey, you got to do 1 through 9 all over again?
I think that
Even if we send it back for just an order?
if it's for just an order, I do think that the best way, again, to do it would be to redo the entire order then at that point, where the judge would have to evaluate each of the claims that are raised and then express its factual basis for either denying or granting. I guess it could change its mind, but in this case, denying each of those points. And in this case, the order largely just says, recites what point 1 is and says denied and goes through the four.
That was my next question. Do you agree with the state that we can resolve some of these issues? We could resolve some of these issues without sending it back?
There's only one where, do you mean just for the order? Is that what we're talking about? Just for the order, there is one issue where the court kind of puts some factual basis to it. I still don't think that that is enough. I think that the best way to resolve this would, one, be have a new PC hearing with a whole new order and factual findings based off of that. If the court doesn't want to do that, still needs to remand for factual findings to be included in an amended order, but it would need to address each one of those points and do so clearly.
Okay.
As to the second and third issues that we raised, both of those really deal with knowledge or making a knowing action. So the second issue is Mr. Boyd's entrance of a guilty plea, that it was not knowing and voluntarily entered. And that's primarily because Mr. Boyd was not provided with discovery prior to entering his guilty plea. And I am not saying that before a criminal defendant can enter a guilty plea, they have to be provided with discovery. But if they have an attorney, their attorney does need to review their discovery before they enter a guilty plea. And in this case, we have testimony at the PC hearing that Mr. Parks, retained trial counsel, at most reviewed less than half of the discovery. The best get that he gives is that he reviewed the discovery that related just to the 6 counts that Mr. Boyd entered guilty pleas for.
But his testimony is also that he told the petitioner, that's all I'm going to look at. If you want to plead guilty, all I'm going to look at is the discovery relating to what you're pleading guilty to.
Yes, Your Honor, but our obligations as attorneys go beyond what a client wants.
But to your knowing claim, I guess is my point, it's not like your client went into this blind. He knew that his attorney had only looked at 1 through 6 and had not looked at 7 through 12 or however many they were. But, he knew that. So it was a knowing plea. He knew exactly what was going on. He knew what the proof was as it relates to the guilty plea.
Yes, Your Honor.
And he chose to plead anyway.
Well, when we're looking at whether or not a criminal defendant has entered a knowing and voluntary plea, there's a 5-step or 5-factor evaluation that we need to consider. And one of those factors is the defendant's relative intelligence. Here, that could be intelligence in general or intelligence as it relates to their case specifically. So Mr. Boyd is certainly an intelligent person. As it relates to this case specifically, our position is that he did lack the intelligence to enter a knowing and voluntary plea, again, because neither he nor his attorney had reviewed all of the discovery. To say that you have reviewed, that you have looked through, or excuse me, to say that you have 900 pages of discovery, I'll get there, but have only looked at the discovery that relates to 6 charges, there's no explanation as to how that was done. If he reviewed all of it and parsed it out, or if it came to him in little bundles where these 10 pages relate to count 1, these relate to count 5, so there's no way of knowing, based on this record, how he actually parsed out this record to say, I've looked at the information for these 6 counts.
Well, let me ask you, at some point, let's see, he pleaded guilty in November, and then at some point, 6 months later, your client received a copy of the discovery, right?
That's my understanding.
Okay. Was there anything provided to the post-conviction court showing that the balance of that discovery that counsel, Mr. Parks, didn't review would have somehow affected, I'm going to prejudice, affected the guilty pleas to what he pleaded guilty to?
The only evidence to that effect comes from Mr. Boyd, where he testified that had he known the information contained in discovery, he wouldn't have entered a guilty plea to any of the offenses, and he would have taken them all to trial. But there wasn't discovery, the packet of discovery wasn't entered as an exhibit, or portions of it weren't shown, that sort of thing, to say this related to this count to support it or refute it, that sort of thing, if that's what you're asking.
I am. Also, I mean, there was the state referred to a statute that limits the TBI's ability to disclose some of this. I guess the danger is that it could be an official statement from an agency, but I remember the disclaimer language on the bottom of the TBI pages. I assume when we look at the record, we're going to see something like that, but I mean, the state couldn't have given it for disclosure anyway, right?
So the specifics of that, I'm going to be honest, I don't know, because I wasn't there. I wasn't involved in this case until after the PC hearing. That's when the public defender's office was appointed for purposes just of appeal. I don't believe that there is a document from TBI basically laying out what the parameters are for the discovery. Mr. Parks testified that he had many back and forths basically with TBI on how the discovery could be shared, who could review it, those sorts of things. But the specifics of that, I just don't know. And when Mr. Parks says that 6 months after Mr. Boyd had entered his guilty plea, he turned over discovery, I assume that that is all 900 pages of it. So I don't know if any of that was limited or redacted based on restrictions from the TBI, just to be honest.
All right, I want to ask you about how the guilty pleas came about. Is there any dispute, anything in the record that it came at least twice from the defendant initiating, I'll plead guilty to that, kind of backward from how it normally happens?
There was, so Mr. Boyd was originally on a $50,000 bond out of Madison County. There were some misdemeanor charges, a driving offense, simple possession, that were picked up in Henderson County, I believe. And once Mr. Boyd was in custody, he was then in custody until his plea date. There is information or testimony at the PC hearing that once he was in custody, the focus really shifted to getting Mr. Boyd out of custody. There were, I think, still 3 months that he spent in custody while that was being worked out. There's only testimony, I believe, of 2 plea offers that were made, and Mr. Parks conveyed both of those to Mr. Boyd while he was in custody through his mother.
That's my question. So the plea offers, so I recall just reading the briefs, but it was defendant or his counsel who approached the state for a plea, and there was the language, the state flat out said no.
I believe that that's correct.
All right. So at the very least, both sides seemed to be involved in considering the plea at that point. It wasn't like the state just came and said, well, you're in jail. Jail's a good motivator.
And there was not to interrupt, sorry, but there was also testimony from Mr. Parks that the initial plea offer would have called for a longer time in jail, and he worked another deal where more convictions would result, but about 3 weeks, maybe a month, something like that, earlier release date would come about. But again, that really kind of relates to our ineffective assistance claim on Mr. Parks. That was negotiated and worked out, it appears, without the benefit of Mr. Parks reviewing the full discovery. And also, Mr. Parks not really communicating with his client. He was in custody at that point. There was testimony about a couple of phone calls, but Mr. Parks does say when it comes to the plea offers, at least, that those were communicated through Mr. Boyd's mother. And I don't believe there's anything in the record to support that Mr. Parks ever came down and met with Mr. Boyd while he was in custody.
And the offer itself was an agreement which, in my experience, and I don't know, but it is rare in Madison County, at least, to get an agreement to straight-up probation under these circumstances. A lot of times it's agreement to a set term, and then the judge will determine the service, right?
I have practiced in this county before, so of course this is all outside of the record. Mr. Boyd was, I believe these were his first criminal convictions, so that wouldn't have been that uncommon, even in this county, to receive a full probationary sentence. Granted, most of the things we see in our office are not someone's first.
Right, but that's what Mr. Parks said, paraphrasing him, it seemed like a pretty good offer.
I believe the judge actually, at the end of the PC hearing, qualified it as a sweetheart deal. That being the case, though, it still doesn't remove the deficiencies from counsel. So one of the issues when we're looking at ineffective assistance is whether or not counsel was deficient. And we, as in our briefs, explain why he is deficient, mostly because dealing with his lack of knowledge about the discovery and not properly reviewing that. But the second prong of that Strickland analysis is essentially, was this harmless? And here, to meet that, you have to show that essentially, but for the deficiencies, there would have been a different outcome. It doesn't have to be a better outcome for Mr. Boyd, it just had to have been a different one. And Mr. Boyd did testify at least a couple of times when asked pointedly at the PC hearing that if he had been allowed to review discovery or if he knew what the full scope of the state's case was against him, he full stop would not have pled to any of the offenses and would have pushed this case to a trial.
So, well, on that, though, let me ask you this. You made a statement when we were talking about whether to send it back for a full hearing or just an order. He said the trial court had made some credibility determinations, and did he make a credibility determination on whether or not he believed your client would not have pled guilty had he known this? Because, well, you know where I'm going with that.
I do.
If he did, then...
I'm going to be honest, Your Honor, I do not think so. I do recall that he accredited the testimony, and I'm out of time, so if I'm finished.
Keep going.
I do believe, or I recall that he specifically accredited the testimony of Mr. Parks, one that he had met and discussed issues at some point with Mr. Boyd, and then also I believe that the main drive was to get out of jail, that sort of thing. But I don't think there was a specific credibility determination as it relates to Mr. Boyd. That would be towards the end of the PC hearing if it is in there, but I don't think that it is.
Well, I know you're out of time, but I want to follow up with something. If if a trial judge says, I accredit trial counsel's testimony that the client was doing anything he could to get out of jail, aren't you then discrediting the petitioner's testimony that, oh, I wanted to go to trial, for instance? Does my question make sense?
It does. I think that
It's not a direct statement, but it's an indirect accreditation or disaccreditation?
Yeah, without a direct, basically disaccreditation, I would say that we have to look at this within the full context of the hearing. And so to say, well, I believe or accredit Mr. Parks when he says that he talked to you and that sort of thing, but to not go that extra step and say, I don't think that you were doing this, I don't believe you basically when you say that you would go to trial. I think that is a very clear distinction. And here it was a very forceful, I would not have pled guilty to any of these offenses, and I would have gone to trial on 13 of them. And I think that pretty well shows that there would have been at least a different procedural result in this case.
All right. Thank you.
Thank you.
We'll give you rebuttal time as well, don't worry.
May it please the court, John Bledsoe on behalf of the state. If I may address the remand issue first, we have acknowledged that consistent with the Supreme Court's recent decision in Tate, a remand would be appropriate. As counsel said, our disagreement is over the scope of that remand. Our argument is based upon Tate itself specifically, where the court was remanding for findings. And what is interesting, and I think is incisive here, is the court recognized that there would be a successor judge because the presiding judge had retired. And so the court recognized a new judge would be appointed and directed that judge, authorized that judge to make findings from the record. But it recognized that if the court found it necessary, the court in its discretion could hold an evidentiary hearing. So the holding of a hearing was tethered to whether a successor judge could or could not make findings from the record. And ultimately, in that case, an order by the successor judge was entered, and then this court resolved the appeal based upon that order.
Without a hearing.
Without a hearing. Now, I'm not sure if this court's opinion following the remand says that, but I can say that because I looked it up, and there was no, the order itself, the trial court order references that it's based upon the pleadings. But there has to be a nexus between sort of the harm and the remedy. And the harm, the error, is the failure to follow the statutory directive to enter written findings of fact. This was a one-page order. It was prepared by the prosecutor for the judge. It does make some findings, but we agree a more fulsome order would be consistent with Tate. Now, if this court disagrees, we've addressed the issues under the existing record.
Do we send it back for everything, or can we piecemeal it?
I think what is most consistent with Tate is for it actually to be sent back for findings on all of the claims. That is what the court did in Tate, and that is actually more efficient. Because, I mean, we have oral findings, and to the point of whether the judge would need a hearing, we do have some pretty extensive oral findings. We have an express adoption of defense counsel's credibility in his recollection of events and presentation of that. And we have discussion of portions of that testimony, that he had reviewed the relevant discovery, that he had discussed that with the petitioner before the plea. But just recognizing that we acknowledge a remand would be appropriate, but in order to make findings. But under the record we have.
Can we put the qualifying language in there that if necessary, a hearing?
I don't think that's what Tate contemplates, because the if necessary portion
Was just because it was a new judge?
is because it was a new judge. And it follows immediately the court giving the successor judge the authority to make findings from the record. And And so those sort of, you kind of read both of those sentences in context, that that's where the provision of an evidentiary hearing falls. There's nothing about this error that calls for a new hearing. The other issue that implicates is, if you have a new hearing, you could have new evidence, you could have new claims. You're granting sort of a windfall for something that the trial court, first of all, erred in not doing and failed to do, but can be corrected by giving the court the opportunity to do that. So we submit that something beyond that limited remand is beyond what Tate authorizes. Just looking at the issues themselves and recognizing once there's an order, if it's consistent, if the court agrees there needs to be a remand order, and if it's consistent with the record we have, I think there's enough as counsel's discussed the issues, and I can as well. I think it's important to sort of put this prosecution in context. There was a pro tem appointed, and this all happened within the course of calendar year 2022. The appointment was in January. The indictment was in May. Mr. Parks was retained and entered an appearance, I think, in July. And then the bond revocation was in September. The plea was in November. So this is a fairly short amount of time. Mr. Parks testified that there was some delay in getting the discovery from TBI because the prosecutor was calling for them to agree to certain limitations that it could not be given to the defendant because of the confidential nature of TBI records. He would not initially agree to that. We don't have a lot of specifics about that. We do know that he eventually got it himself. He reviewed the discovery that was relevant to these 6 charges. But I think what's important to note is once the bond revocation occurred in September, the primary interest of the petitioner, this is according to Mr. Parks, was to get out. And he's like, okay, well, there's a few ways we can look at that. And part of that turns on how hard the defendant wishes to fight the charges. Because if you want to, you can't just plead guilty to get out if the evidence isn't there and you strenuously disagree with the charges. So part of his advice to him was informing him that the discovery he had reviewed showed that there was evidence from which the state could convict him. His disagreement is he did not believe his conduct qualified for those crimes, and they had discussions about that. But ultimately, what he presented to the petitioner was a choice. We can seek to reinstate bond. There would have to be a change of show a change of circumstances to do that. Or he can attempt to negotiate the best possible deal he can with the prosecutor to get him out, because he was facing a trial date that had been extended to the following May, because counsel would still need to review all 900 pages of discovery if they went to trial, if this were going to be a hard-fought case. So counsel recognized if they're not going to do that, if his interest is so important that he wants to find a way to not spend the next 9 months in confinement, they can pursue a plea agreement, but he's not going to have the time to review all 900 pages.
And I get that. However, I guess the question that kind of keeps popping up to me is, how am I zealously advocating for and representing my client if I'm not aware of 100% of what the state has on my client? Because buried in that 900 pages may be the smoking gun that shows that my client is maybe not guilty of some or all of what they're charging him with.
Right. Counsel has an obligation to look at what is enough to see if they're going to have a viable defense. So I agree, there has to be some investigation there. I think my point is this record shows there was sufficient investigation of that here, because they couldn't change the fact this is going to take months for him with his other obligations, for other clients and his position as a magistrate as well, to factor that in. But the other key here is he provided that choice to Mr. Boyd. He's like, we can do either of these. And ultimately, Mr. Boyd's concern is they would prepare for a motion hearing to reinstate bond, and it would be denied. And so he started negotiating. He was very candid that you can have a more aggressive stance with opposing counsel if you're building up to a big trial, or you can try to build a very good rapport. And there was, initially, I think, they weren't even going to, consider something of this nature. They then, and we do not have specifics in the record about the different deals or what went back and forth other than the final one. But there was discussion of an agreement that would have him getting out sometime in December. And his response was that he wanted to be out at the November hearing. And eventually, they reached what opposing counsel mentioned, that the trial court said sweetheart deal. And the trial court may have said that, but I know the prosecutor said that. Because by the time we got to the post-conviction hearing, it was a second pro tem office. And that prosecutor was very candid. She would not have made an offer like this. He got a very favorable deal. 7 of his 13 felony charges were dismissed, and he ultimately served about 7 weeks on 6 felonies. I mean, that's his choice, and it's just as it's his choice to pursue post-conviction relief. And he was pretty clear at the hearing that once he got the discovery himself, he did not believe that the evidence included in it established the offenses. Mr. Parks disagreed based upon what he reviewed, but
Let me stop there because this is a part that I've been trying to figure out.
Mm-hmm.
We don't have anything in the record that shows what was turned over and then what was received later.
we do not. I don't believe we have any piece of the discovery in the record. We're sort of limited in several ways because we don't have any of the trial court pleadings. We just have the post-conviction pleadings. A lot of these dates I've mentioned, I've gleaned from representations made in pleadings.
Right.
We also have, so because of that, we don't have the indictments, the plea paperwork, or the judgments. They are appended to opposing counsel's brief. They're not in the record. You also, and this is another unique feature of this case, sometimes in post-conviction review, you may have information that comes either through formal testimony or representations made by the prosecutor, but you had prosecutor number 3 at the post-conviction hearing, and this conduct was through prosecutor number 2. We have a lot of gaps in that. Of course, that weighs against the appellant and the ability to show the ability of showing a knowing plea and ineffective assistance. But putting all of that in context, it shows that based upon the accreditation of Mr. Parks' testimony by the trial court, that he explained the nature of the evidence that the state had based upon the discovery he reviewed that was relevant to these charges. And upon the available options that were presented, he explained them to the petitioner, and it was ultimately the petitioner who made the decision to move forward. The plea was knowing. He was competent to make that decision. Mr. Parks testified he had no question that the petitioner was competent and understood the circumstances. Again, the petitioner disagreed with whether what he did was culpable conduct, but they discussed that. And really a lot of that also factors into whether there was deficient performance. I think Mr. Parks had a lot of engagement with the petitioner trying to explain the circumstances to him. They had, I think, 5 conversations during the 7 weeks he was confined, a total of 10 to 15 conversations. Some of those were through his mother, which was authorized by him. That there's no showing of deficient performance in how counsel responded to the circumstances in this case based upon the time limit, I wouldn't say time limitations, but the circumstance of the short span of time that we had, and the petitioner's strong interest in a resolution or in a circumstance, maybe not the resolution, but ultimately his decision was to seek a resolution that would get him out. Finally, as to the prejudice issue, opposing counsel said that he testified that had he known this, he wouldn't have pled. I'm not disagreeing with that at all. I don't recall seeing that specific statement, but what I will acknowledge is it's pretty clear from the hearing, because he represented himself at the hearing, is that through his examination of Mr. Parks and then his own testimony and his argument, that it was him receiving the discovery that was a motivator for the post-conviction petition. So I don't know if we necessarily have a statement of that, but I don't think that's an unfair view from it. Of course, if there's a remand, that's an issue that perhaps the trial court could address more specifically in terms of whether there is an accreditation of representation that had he gotten this, had there been more effort or actions by counsel, he would not have pled guilty.
So I guess that kind of answers the question I asked counsel. Is the trial court did or did not make any true accreditation directly towards the petitioner? It was more towards, I believe trial counsel this, I believe trial counsel this.
Correct. And there was a good bit of disagreement between them.
Right.
So you have him accrediting that. I don't recall a lot of findings beyond that on particular issues, other than the individual statements that are in the order that was prepared and signed.
Because, I mean, as you well know, I mean, we get different types of orders all the time, but lots of times you'll get I credit trial counsel and I find the petitioner's counsel not credible.
Right.
Petitioner's testimony not credible. But here you just have him focusing on one person versus an accreditation or discreditation of both.
I think he was pretty clear. I don't recall his exact words. It's the beginning of his oral findings that he's saying, I accredit Mr. Parks and not the petitioner to the extent they disagree. But I also recognize that may not necessarily answer whether he discredited something that, a question as to, well, if you had gotten this, would you, yes or no? Well, that, to be honest, I'm not sure adopting one over the other necessarily answers that question, but a remand order perhaps would.
Would clarify all that.
That's just an example of where having the written findings and conclusions of law is obviously of benefit and necessary for this court. Unless the court has further questions, we ask the court to authorize a limited remand, as we have argued, and ultimately, should the findings be consistent with what we have in the existing record, the court affirm.
Thank you.
Thank you.
Thank you, Your Honor. Just briefly, I'm going to touch on some of the things that my friend on the other side brought up. As it relates to the first issue, under Tate, I do think that this court, if it wanted to just do a limited remand for additional findings to be added to an amended order, could still, given the amount of time that has passed, I think it would still be appropriate for this court to say if another hearing needed to be conducted, that the trial court would be able to do that. My reading of Tate doesn't foreclose that as a possibility. I do understand it's in a little bit of different posture because there was a new trial court there. And then also, as it relates to the timeline, I would just like to highlight for the court that the indictment came down in June of 2022. Mr. Parks was hired, I believe, in July, and then Mr. Boyd is arrested in August. So we have 3 months there. Mr. Parks testifies that he does not get the full discovery in this case until September of 2022, and then Mr. Boyd enters a plea in November. So there's at least 2 months there for Mr. Parks to have plenty of time to have reviewed 900 pages of discovery. All things being equal, I'm not saying that he has to sit down and pore over each individual page and he has to know it by heart, but a good attorney adhering to our ethical standards, complying with ABA standards, would have reviewed that material to be able to say, this is a good plea, you should accept it for X, Y, and Z. The only thing that I am aware of at the PC hearing or in the record that Mr. Parks said that this would have been a good plea and in Mr. Boyd's interest to accept it was because his measure of what is a good plea is it less than what you could get at trial. So we have 6 convictions here, it's a probation sentence as opposed to 13 possible convictions following trial.
How do you square, I guess, the attorney's duty to review all the discovery with I believe there was testimony, Mr. Parks' testimony, that the petitioner was very involved in filling in the gaps or providing his own recollection of that before he pleaded guilty. I mean, don't we have to look at all that?
So a client's interests are certainly something that has to be taken into consideration for anyone who's representing a criminal defendant. But we have, as attorneys, as a regulating body. We have our internal ethical obligations, and when it comes to ineffective assistance, courts time and time again point to the ABA standards, whereby you have to possess enough information to confidently convey upon your client what the situation
Okay,
is.
but I'm going back to this, the problem that I'm having. We don't know what wasn't revealed at the time the plea was done. I mean, the record, the discovery has not been sectioned to see what was received before and what was received after, to even determine whether or not if there was any basis to believe there's prejudice.
So Mr. Parks testified at the PC hearing that he had received all of the discovery by September of 2022.
Okay.
And the plea was not entered until November of 2022. So Mr. Parks had all of the discovery well before Mr. Boyd ever entered a guilty plea.
I understand that.
And to say that I have other obligations or other clients, that sort of thing, so I didn't look at all of the discovery, but I somehow was able to parse out what was relevant to these 6 counts, and I reviewed that. I think that is just defies the reality of the situation.
But it still is a matter of proof in it. It's the defendant still has the burden, or the petitioner still has the burden to prove by clear and convincing evidence that had he had this information, and the information was of such magnitude. Back in the old days when I was prosecuting, you get these police reports that were voluminous, and you'd find sections that were just copies of, they got a copy from another department and they put it in there, and you got duplicates and
Yes, Your Honor.
stuff. And so, the question is, and I know the defendant says, well, it would have made a difference, but we don't know what was turned over, we don't know what was received late, and what the differences were.
Well, Your Honor, I think that would only, if I may answer, I think that would only be important or significant for this court if it was tasked with making a credibility determination of Mr. Boyd's testimony at the PC hearing, where he said, once I had all of the discovery and I reviewed it, I absolutely would not have pled guilty. But this court doesn't make credibility determinations. That's something for the trial court to do. So I think that the record is sufficient to say that there would have been a different result, which in this case would have been a trial on 13 felony counts as opposed to a plea. If there are no further questions, again, we ask that this court first remand this matter back to the trial court for a new PC hearing, or in the alternative, allow or in addition to, really, allow Mr. Boyd to withdraw his guilty plea and remand to the trial court for new proceedings. Thank you.
Thank you, counsel. Anything further, Madam Clerk?
No, Your Honor.
And we will stand adjourned until the call of the next docket.
All right.